We would now move on to our next session, which is on the Indian jurisprudence on SEP. There have been several judgments delivered in the area of SEPs, and few are sub judice. Indian jurisprudence is evolving in this space, and globally it is being watched. These have become a benchmark as well. We thought it therefore prudent to set up a constellation of experts who could delve a bit deeply on the Indian case laws. So Chitra Iyer from Philips would be chairing the session. Before I give the floor to Chitra, I would just like to briefly introduce her. So Chitra was a scientist doing molecular research for 10 years before she moved into the field of IP and law. She has a combined experience of around 15 years in the areas of IP and law, which includes private practice and as in-house counsel. She has held leadership positions for the last 17 years in various MNCs in India and Europe, while handling a wide range of technology areas such as pharma, NCE and generics, biotech, material science, and engineering, to name a few. Chitra was head of the IP department for EI DuPont and Philips with responsibilities for Southeast Asia, ASEAN, and ANZ. And she actively supports IP advocacy matters as well. So, Chitra, the floor is all yours for the session, and you may want to introduce briefly the panelists for your session.
Hello.
Thank you.
Just let me know if I'm audible.
Yeah, you are.
Thank you so much, Hiteshi, and thanks a lot for the participants. My sincere thanks to also the panelists for the earlier sessions. It was a brilliant session. I only hope that ours can be as good as that. And but we have a stellar group in our panel, and I would request everybody to be a little more patient and stay on. I'm sure that you will not regret that. And we have very good speakers in this session. Let me start with introducing them one by one in the interest of time. So to start with Mr. Praveen Anand, who is managing partner Anandan Anand. Mr. Anand is an iconic figure in IP, and we all know that. I doubt there's anybody in the IP field who's not really heard of Mr. Anand. He's a law graduate and IP lawyer and has been a counsel in several landmark IP cases, including those involving the first Anton Piler case and the first SEP litigation in the Philips case, to name a few. Of course, there are many more. His innovative and creative approach towards IP is reflected across pioneering initiatives the firm has taken to develop unique IP concepts and products as well. Mr. Anand is a co-author of Hasbury's Law of India, author of many prestigious Indian chapters pertaining to patents, copyright, media, telecommunication, trade secret, and so on. He's also on the editorial board of several journals. He's got several awards. He's got the AIPPI Merit Award. He's the most innovative lawyer in Asia Pacific, National Innovation Foundation Award. And as I recall, recently Mr. Anand has also been inducted into the IPBC Hall of Fame. Congratulations, Mr. Anand. I'll then move on to Saya. Saya is also a leading practitioner in the field of standard essential patents. She is a graduate in Philips and done her post-graduation diploma in IPR law and securities and banking laws. She heads one of the patent litigation teams and has handled several landmark cases herself. She has an extensive experience in relation to disputes pertaining to SEPs and also has experience of negotiating and executing Frand deal on behalf of SEP owners. Our third panelist is Mr. Jim Hallan. He's the Senior Director from Licensing at Interdigital. Jim represents Interdigital before Standard Setting Organization IPR Policy Committee and working groups regarding patent, standard setting, competition, and licensing policy matters, and assisting with strategy regarding patent policy, competition policy, IPR licensing, etc. He's had various positions involving standard policy and patent strategy and compliance in several firms, including Research in Motion, Siemens, etc. And he earned a JD from Wayne State University Law School and MBA from the University of Texas at Dallas, and master's degree in computer science and bachelor's in chemistry, both in the Wayne State. I'll go to the fourth panelist we have, again, another distinguished speaker. Miss Shimoyi Deb, who's a partner in competition law at P&A Law Office. Ms. Deb is an NLU Raipur alumni, and she's an expert in competition law for more than 5 years now, and has been practicing at P&A law offices. She's worked also with Competition Commission of India previously, And she's also a recipient of Young Achievers of the Year Award 2021. So I hope I did justice. I'm not sure I must have done complete justice, but I'll move on to the panel because I'm sure our audience is eagerly looking forward to your comments and views on various burning topics. Okay, so let me start with the panel. I hope I have all the panelists. I do see Jim, I see Mr. Anand, I see Saya, and I see Srimoy. Thank you so much, everyone, for being in this panel. So let me start. I'm not sure if all the participants were there in the earlier sessions, which were also very, very interesting. I'll start with a very general question for Jim. Start with a question on the basics of SCP. And Jim, could you say something about to the students and professionals having on the standard setting process? Could you talk a little bit about overview of standards and the standard setting process itself? Just in case some of our participants missed the earlier sessions, we could start with a little bit of the background.
Chitra, thank you. And thank you to the organizers for inviting me. Traditional disclaimer, my views are my own. They don't represent those of my company necessarily. I hope you can hear me okay. Okay, great, thank you. So I was fortunate to attend some of the prior sessions, and the one that was not before the fireside chat, but the one on global SEP. There was a question asked by the moderator, and I think all of the panelists answered in a way that addressed everything I was going to say. But I'll just go over quickly the standardization process. And I noticed there was a question in the chat as well that talked about indigenous type innovation and kind of maybe a version of 3G, 4G, or 5G that was specific to India. And if you can do that, that did not violate SEPs. There's a lot of interesting topics. I'm really fascinated by this conference, and so and again, you just want me to focus on this one little narrow spot, which I will. But there's a lot that I would love to also talk about. So as I'm hoping everybody has the appreciation by now, standardization, the whole process of standardization is very, very complex. One of the things that I like to differentiate between is an SSO and an SDO to start off with. So I think of those things as two separate concepts. The first one, an SSO, is a standard setting organization. So in my mind, that's an organization that will choose between copper pipes or PVC pipes, or maybe they'll choose to use A4 type paper, or the letter size type paper. So it's sort of choosing one or the other. Which types of outlets do we use? What side of the road do we drive on? That kind of thing. That sets a standard. And I think you see that more commonly in like safety type domain, whether it's fire safety, building safety, those types of areas. I think you see SSOs more pop up kind of to handle that solution. But what I want to talk about more specifically are SDOs, standards development organizations, and that's where there's no set solution to start off with. So it's not picking winners and losers. It's not selecting a technology off a shelf like you would a box of cereal or something like that from a grocery store. It's getting a bunch of people together who could represent any aspect along the supply chain, right? I mean, you could, speaking specifically about cellular development, you could have people in the room that are government officials that care about spectrum. You could have people in the room that are operators that also care about spectrum, but care about how that spectrum then affects base stations, and then then the ultimate consumer that will pay for their services. Base station vendors, smartphone OEMs, module makers, chip makers, and then companies like mine that are research and development labs. And there was an interesting comment made by one of the prior panelists that it's hard to make standardization a success because there's a lot of times you go to these meetings, you've made this enormous investment, and then your submission doesn't get approved. It doesn't get voted on. So you have to go back to the drawing board. And that's one of those things that's important to understand in this process. So imagine you have all these players in the ecosystem, and what was I heard earlier, maybe 1,000 people, but this tends to be in more than the hundreds of attend these meetings, and they get the information ahead of time, and then and then they sort of vote on what they think is a good solution, or they vote on what the submission that they've made or a change request, and it's a consensus-based organization, most likely. So consensus can be defined a variety of ways. The way Etsy and the sort of 3GPP group just defines consensus is lack of sustained objection. So if you think about that concept, you really have to have all these hundreds of people to really kind of come together and just not object, right, to the technology that's getting introduced. And that takes a lot of work. So there's a lot of work and investment that goes on by these companies. And what was also said earlier by Eric, who made a really great point, is that my company in particular, InterDigital, we do invest about 20 to 22% of our annual revenue in standardization and in R&D. So we are we are a small company, but we are we like to say we punch above our weight. So we do actively engage in the standardization process. But just to make sure everyone understands, global standardization or in the interoperability of cellular standards is important for the marketplace. Like, I don't want to have to leave the US and then like switch phones when I'm in India, and then switch phones again when I'm in China, and switch phones yet again when I go to the EU. It'd be nice to just carry my one phone that's interoperable with all the geographies and with everybody. And then when I go to India and China and Europe, I just pick up my phone and make my phone call as I would if I was home in the US. So that's kind of nice. That benefits consumers, which I think is what this is all about at the end of the day, the benefit to the consumer. But some of the so if you can still imagine this process, they're usually 10-year undertakings. And so right now in 2020, we actually had the ITU, which is the organization based out of Geneva. They created now IMT 2030, which is 6G. So they expect IMT 2030 to be finalized by 2030, or 6G to be finalized by 2030. Well, in 2010, they created IMT 2020, which was 5G. So every 10 years, you start the investment process. And as was said earlier, you had Release 15 came out with 5G NR not too long ago. I think it was Release 17 where you had India 5GI. The TSDSI opted to focus more on the 3GPP release, which I think was a good move because, again, you want these things to be interoperable, and you don't want to have country-specific flavors of the different cellular standards. But so when we had Release 15 that was just approved in the last couple of years, and 16 and 17, and I think 18 is what they're working on right now. We started that investment a decade ago. So now that we go and talk to potential licensees and try to get a return on that investment, you got to think about, we're trying to get a return off the investment we made 6, 8, 10 years ago, not like what we're investing in today, because that return on the investment pays for what we did, but then also feeds into the system of us now being able to afford to send people and work on the development and the next generation of the standard. So and one of the difficulties we come across at times, is the licensees, that potential licensees that wait the 7, 8, 10 years to enter into any license agreements. And we're not a litigious organization. We do have to sue to protect our rights. but only after we've been trying to negotiate for a long time. And one of the drawbacks, I think at least from our side is oh, she tell you've raised your hand. Sorry.
No, I think it's a signal to go to the next speaker. So, Jim, please, I would request you to wind this so I can go
keep
to the.
talking and talking and talking. You got to stop me. So, okay, I'll stop there.
So, Jim, I totally understand where you come from. And in the interest of time, I wish we could have a day-long session on this, but I'm sure we will have again in the future. I'll move on to Mr. Anand now because I think we have something to discuss on the Indian jurisprudence as it's developing. So, Mr. Anand, I would now, as somebody being in this field for many, many years, what are your views on speedy litigation and SEP adjudication system? Do you think it can actually influence the country's economy? And if so, how?
Well, I think, can you hear me well? You can hear me?
Yes, I can hear you.
The first and most important thing is the fact that when the Commercial Courts Act was introduced, it introduced a culture which the courts and the legislators thought that speed was the need of the hour. So the whole commercial courts environment created that desire. The implementation by or an implementer or an infringer may make a lot of money making devices that infringe technologies, and after making money may disappear and become bankrupt. And so the concept of dilatory tactics and holdout are well known during negotiation processes, during litigation. The result, right owners who've developed the technologies are left without anything and just twiddling their thumbs. And it's well known now and documented that market share, once destroyed, is very, very difficult to recoup. And Frand is like a right owner having his hands tied at the back because he has no choice to decide whether to grant or not to grant a license, and a very limited choice to decide the terms. And so, with that, to prove patents as being valid and essential requires huge effort in terms of time, money, and effort. And if there is no deterrence, even existing licensees refuse to pay or to renew their licenses. The paradigm being, why should I pay if he isn't? That's well documented across not only SEPs, but other fields of IP as well. For example, copyright. In the film world, in the music world, and in the book world. Then patent life is always limited. And there's a lot of time that's spent in prosecution and acquiring a patent. And that time of prosecution eats into the life of the patent. So it may take 8 years before you get your patent. And if after that, the negotiation in SEP litigation is considered mandatory. So if after that you have to negotiate rather than straight away suing somebody, which you would otherwise do if you haven't had a patent and somebody were infringing, that eats further into your time. So years and years go by, and by the time you realize that you have a case, very little term is left. And with that, some courts have started to refuse injunctions if only a few years of the patent term is left. We've seen that in several cases. And also, if a patent expires during the lifetime of the litigation, the kind of importance which is given, either by the courts or even otherwise, in preference to other matters where patents are still alive, is much lower. So, in all, you gather all these factors and you find that the only answer is speedy litigation. That's the importance of speed.
Thank you very much, Mr. Anand, for articulating it so well. I'm sure that I'm not speaking much on this topic because I have a sense that I might be a little biased on the other side. So I'm keeping my views to myself at the moment. So I'll just go on to the next topic here, and that is to think about discuss about the key benefits and challenges of SEP litigation in India. So Mr. Anand, and then to you, Saya, after Mr. Anand in this topic.
Let's do that. I
Yes.
think I'll just give them as short points so that Saya can contribute, who also has outstanding experience. Well, I don't, but she does. Cost is one of the most important benefits of litigating in India. The cost of litigation as compared to other jurisdictions is massively reduced. The other benefit is the fact that Indian courts are surprisingly easier on interim reliefs, interim arrangements than in some of the other jurisdictions. There's very quick interim arrangements, discovery, grant of interrogatories, which might give the plaintiff or at least the court a good sense of the annual sales in terms of numbers, in terms of revenue that the defendants had made while selling their infringing devices. Then we are hopeful of security and interim security even prior to the arguments on merits in what is coming to be known as a pro tem order. And that pro tem jurisprudence, we are hopeful, would develop. Also, we are hopeful that Frand-only trials, expedited Frand-only trials, would be a great benefit. And one more benefit is the fact that anti-suit injunctions have been granted in India, and even coordinate anti-suit injunctions, where there was just an apprehension that there would be an anti-suit order and anti-suit coordinate injunctions have been granted. And one more thing, the courts recently, the Supreme Court in the UFLEX case said actual costs ought to be granted in litigation.
Okay.
So that's another wonderful variation. And finally, pre-grant litigation, pre-litigation mediation. A lot of cases, SEP cases, have been settled in pre-litigation mediation. And that means without spending much in terms of, in the number of, in a few months, 6 to 8 months, as many as 10 cases have been disposed of without filing lawsuits. I think these are the key benefits that I see in the Indian system.
Thank you, Mr. Anand. Over to you, Saya, for your views.
Okay. So Chitra, if you look at the market dynamics as far as electronic goods are concerned, specifically handsets, right, which are the so-called the center of SEP litigations and standards nowadays, specifically in India. Except maybe for your Apple and Samsung, we see increasingly all the vendors are Chinese vendors, right? Be it your Oppo, your Vivo, your Xiaomi, Redmi, Realme, till the 5G fiasco, Huawei was a big player. And for reasons I won't expound upon, SEP proprietors are a bit hesitant initiating litigation in China against such parties. So India then offers a neutral venue, a neutral jurisdiction, especially when most of these players have their market hub, their manufacturing hub, their sales specifically limited only to Asia, where India forms, like, I would say 40-50% of the continent, or at least 30% of it. Remaining is China and other Southeast Asian countries. So from that perspective, India is a big advantage for SEP proprietors as a jurisdiction, especially if the vendor is just located in these nations. Secondly, based on my past experience, whenever my client comes over and we discuss SEP litigation, the end game for a proprietor, as opposed to say an implementation patent, is never injunction. It is always license, right? And if we historically look at the various SEP cases that has been dealt with by Indian courts, 80 to 90% of them have resulted in settlement. Courtesy, as Mr. Arden pointed out, interim arrangements or pro tem orders. whereby deposits were directed to be made either directly to the SEP proprietor, or they were directed to be made to the court, or the implementer was asked to pay bank guarantees, or the implementer was asked to pledge a property, or the implementer was asked to maintain a certain amount. So, in the amount of litigation that has been instituted in our country, the end game, that is getting a license, is able to be executed early on.
Your videos aren't showing. I think there's some.
Okay, let me try again.
Glitch, I guess, from your end.
Well, I can
Is
see
it-
Saya. Hiteshi, I can see her.
Chitra, your voice is breaking.
I think our connections are bad for Hiteshi. Can you see me now?
I can see her.
Even I can see you, Saya.
Saya, I would
Okay.
suggest continue, and if there's a problem, we will see.
Okay. So as I was saying, that parties, SEP proprietors tend to litigate only when, as Jim pointed out, they reach an impasse, because the intent is always to enter into a license arrangement. So Indian litigation so far, in 80 to 90% cases that have been instituted here, have resulted in that. Challenges, yes, there are certain challenges. We know for a fact that there is a bit of a bottleneck as far as final arguments or disposals are concerned. The other challenges, as compared to other jurisdictions, where, for example, in US, you have the concept of treble damages, something of that sort we haven't seen as of yet. As Mr. Anand just pointed out, that Supreme Court has now sort of ordered that you can go for actual costs. So good thing we are waiting towards a positive change. But that results in, I would say, very out of the box arguments or defenses which an implementer raises, right? So what if I've advertised my device to be 2G, 3G compliant? That doesn't mean I'm using the standardized technology. It is some other 2G, 3G technology, etc., which I'm using. You don't come after me, go after the chipset. Don't come after me, go out of the operating system, etc. Which arguments I believe would not have been amenable or would not have been easily taken up in other jurisdictions where there are excessive costs for raising frivolous suits. But we have seen changes in our legislature. We've seen provisions coming into picture in patent rules and Commercial Codes Act to tackle with that, and hopefully that will improve. So this, as per me, are broadly the benefits and challenges as far as SAP litigation in India is concerned.
I just
Thank
add
you.
one or two challenges.
Sure.
On challenges, I think time limits have now been provided in our rules, but they are yet to be strictly implemented. So that if they are implemented, in that way, we'll be able to achieve an early disposal of cases. Second, as Saya pointed out, damages, even if granted, are very difficult to collect. So if you actually calculate all the various cases where damages were granted, the percentage of collections would probably be not more than 30%. And that's the need, therefore, to secure the plaintiff at the beginning of the trial. Because by the time the trial ends, all assets have been frittered away or transferred to companies which are at arm's length. The third is the changes in the roster. Very often, you argue a matter to a great length, and the roster changes. There used to be a time when you could request the judge to retain a part heard matter, but there is a little bit of discretion that the judge has. If the judge is on a very busy roster, the successor roster, he might just release the matter after hearing it for a long time. That's another issue. Then the confidentiality regime at the moment, there is no clarity on providing patent license agreements, whether they should be provided to whom, whether it should be just on a redacted basis or what. Those are things that need a certain amount of clarity. These are the challenges.
Okay. Thank you, Mr. Anand. Now, with every discussion we have on SCP, there is also this effect that we have of the Competition Commission, which probably has the role of balancing the system a little bit. So, and competition law is geared towards maintaining a market order and maximizing consumer welfare. That's their role. So I would request Shrimoy to comment on that. Could you please tell us the scope of intervention by competition authorities and how do you think the balance is maintained, if there's a balance?
Yes, yes. Thank you so much for this opportunity. So basically, intellectual property rights, what they essentially do is that they are rights which are given by law to protect and promote creativity. They have these inbuilt mechanisms built in themselves to ensure that there is no overprotection which is being granted, so that, or which could actually lead to the society being deprived of the benefits of creation or creativity, benefits of innovation. So there is a very balanced approach which has been which forms the foundation of these IP laws. Now the IP laws exist on the one hand, and on the other hand there are these competition laws which exist. So competition law is to ensure that the society is getting benefit of the innovation and development which is happening at the same time. So there is a fine balance which needs to be maintained when it comes to the question of or the scope of intervention of competition authorities in matters which are relating to intellectual property rights, especially standard essential patents, because time has proven that standardization and the whole process of standardization has led to innovation. They have led to consumer benefits. They have also led to a widespread dissemination of technology. They have helped in interoperability. They have basically brought the developed nations, and the underdeveloped nations all at the same pedestal, at least when it comes to the question of access of technology. So now the question really which arises is, to what extent should the competition authorities intervene? So the real the whole issue of the whole issue which involves competition intervention in the realm of standard essential patents, they arise from negotiations between the standard essential patent holders on the one hand and the implementers on the other hand. So the competition authorities must necessarily be very careful about the fact that they should look at the circumstances in a holistic manner, so as to avoid either being a tool in the hand of the SEP owner or the implementers. So that's and apart from that, I mean, the intervention should only be made at places where such intervention is absolutely necessary. There, when there is like clear evidence of a competition harm, because premature intervention also results in the there is a risk that the premature intervention may stifle innovation, may stifle competition, may stifle development. So that's all I want to say in response to your question.
Shrimoy, that was quite insightful. I'll just a little bit talk about the rigor that's involved in litigation in India, mostly for the benefit of our audiences, which are students and who are at least aspirational litigants in the future. I would like to ask Saya if she has a view on the litigation preparation in India, and she has some idea on how it is versus other jurisdictions.
So Chitra, the litigation preparation in India for standard essential patents, so for patents in general, because now we are governed by patent rules, is a bit extensive as compared to other jurisdictions. There are requirements where you are asked to disclose about all corresponding patent applications and any orders relating to their revocation or amendment in various jurisdictions. You have to disclose whether there is any pending litigation or litigation that has concluded with respect to your suit patent. If it's an SEP, you have to disclose details of your comparable licenses. Obviously, you have the option to doing that in a sealed cover or asking for a constitution of confidentiality club. But yes, there are multiple details and information which is sought at the time of filing of the litigation, which makes the entire filing process in India rather top heavy as compared to other jurisdictions. However, we need to sort of understand the logic behind it. See, the peculiarity of our judicial system, and we can't sort of turn our back to it, is that, we are a populous nation. We are the second most populous country in the world. There are a lot of litigation which are pending. Patent rights being limited by terms, 20 years. There is a little bit of bottleneck which we see at final hearing. So the courts, being very well aware of that fact, tends to protect the patentee or the right owner by passing interim orders or ex parte orders. We've not seen ex parte orders of late in SEP cases, but as I said, the rules are applicable for all patent cases irrespective. So when on the day one, if you come and if you're asking for an injunction, an ex parte injunction, I think the intent behind these rules and these extensive information which is now being sought is that to ensure that the courts do not they are being cautious enough so that they do not err, as opposed to say a US where or a UK where interim relief is something which is not granted. Parties themselves have the time to sort of file for discoveries, interrogations, etc. So any or all aspects relating to suppression or certain invention having been sort of revoked in other jurisdiction, or certain observations being made with respect to the patented invention would come to fore before the judge before he or she sits and starts adjudicating the issue at the final stage. So to prevent those aspects, because courts tend to grant ex partes, because court tends to grant interim, because courts tend to grant pro tem, on the basis mostly assertions made by the plaintiff, just to ensure that there are no orders which may adversely affect even the implementer or the defendant because of certain misrepresentation or suppression or lack of communication. All these extensive details and information is required at the time of filing. But I would like to conclude by saying I do not believe that that has acted as a deterrent in any manner towards filing in India. In the so-called multi-jurisdictional SEP prong litigation that we're seeing of late, India tends to feature quite prominently. So I do not believe that that would be an issue for an SEP proprietor or patent proprietor in general.
And hopefully that would speed up things a little bit in the future. Let's hope for that. So, Jim, by any chance, do you have any comments on this? If you don't, also I understand.
I think at this time I'm not able to comment given the litigation that we have ongoing in India. But when it's over, I'd like to be invited back and I can provide comments.
We'll keep that in mind for the future. Sure. So I'll move on to the next question now that I have here. That's for Mr. Anand. Mr. Anand, do you have, by any chance, can you comment on how does India compare in the effectiveness of a judicial system? I mean, when you compare it with maybe any other country, I'm just taking examples of UK, Germany, or maybe Netherlands. Are there any best practices that could be adopted? Because, for instance, I was in one of the hearings to the UK. I saw that there were transcripts taken down when the hearing happened. I thought it was very efficient way of doing things because that involves a certain level of integrity and honesty when submissions are made in the court for both parties, and then that's available in the future for reference. I thought that was a very good system, and I don't know if you have any other thoughts on this. It's a very general brainstorming kind of question.
I think I've already dealt with the benefits in the benefits comments which I gave earlier, and those benefits I had kind of mentioned with reference to the jurisdiction, other jurisdictions. But one thing is very clear that if an SEP owner at the present moment is thinking about let's say a handful, less than five jurisdictions to sue in, then India is, we've seen by experience, India is featuring in those five, which obviously means that the market perception is that you can get a fair trial, reasonably quick end result, and a good chance of in case there is unwillingness, a good chance of the possibility of an injunction, which puts pressure for a settlement. And I think, and the kind of common law safeguards and the statutory safeguards that we have in India, they ensure that fairness is maintained. Now, having said that, best practices. I think best practices are very important. First and foremost, I feel that in SEP litigation, or for that matter, any patent litigation, it's very important to identify the experts at the earlier stage. Because my own experience has been that a lot of time is lost in identifying the external experts, and that adds to the length of the litigation. Second, it's very important, and very few people see the importance of this till it actually happens to them, is to have a constituted attorney located in India, a confidential person, of course, a trusted person, but a constituted attorney who could quickly sign papers so that your speed of doing something in court, like filing an application or a response or a rejoinder or a replication, is very, very quick. That's very important. If documents have to be sent to another country and notarized, in some situations apostilled, in some situations legalized, and then sent back, that process is a dead process. Right now, we have some benefits of the pandemic where things were exempted, and certain processes were exempted. And so it was a little speedier because of that. But when we return to normalcy, then the importance of having a local constituted attorney will be realized. Then shorter planes, very important. Shorter planes, lesser documents, more focused cases. Because time and again, courts have remarked that the number of documents are too many, the planes are too large, too long, and it's become so bulky and cumbersome. What that also means is 3 to 5 patents, perhaps, as the ideal number to sue on. In some countries, each patent is a separate lawsuit, like Germany. In some countries, like UK, even if you have multiple patents in a lawsuit, there are separate trials for patent. Here we have a unified trial, which means a lot of saving of time, cost, and money, and expert evidence. But at the same time, you can, if you make it too large, it can get too cumbersome. You make it too small, then you could be standing on or hanging by a thread. If the thread snaps in, let's say, China, the patent is invalidated, then there's a sudden question mark put on the validity, although it may have been granted in 20, 30 other countries of the world. Keep third-party license agreements ready with you in sealed covers. Very important, because the judge might require you to show them to the opposite party, or at least attorney eyes only, or in a redacted form, or to show them to the judge. But therefore, keeping them ready itself is an important practice. Keep the calculations for the last paid rents, or the per device royalties, or the lump sum payment during the length of the litigation, as a measure of what should be the pro tem amount, should also be calculated beforehand. Right in the middle of arguments, you're asked to do that, that's going to take a long time, and that's going to add to delay. Must attempt to persuade the court to get an attorney's eyes only confidentiality order if PLAs have to be, if patent license agreements have to be shown to the opposite party. And I believe that parties should agree to an expedited Frand trial, because most of the litigation really centers around commercial terms. And if the defendant is willing to take a license, then it all boils down to how much. And so that means you could expedite the Frand trial. That's the way Indian courts would go. However, having said that, one thing that is unlikely to happen in India is for there to be an international injunction, because Indian courts will not exercise that kind of a jurisdiction, or even to pass an international Frand rate. Indian courts are unlikely to do what was done in Unwired Planet or in China, or now even in Netherlands. Indian courts will not do that. Indian courts will not allow anyone else to stop their procedures, and therefore the anti-suit injunction. But they will also not encroach on the jurisdiction of other courts without knowing it all.
Yeah. Thank you, Mr. Anand. Regarding the point on attorney's eyes only, without sounding biased, I would just like to say that it becomes very difficult to control to the extent that this confidential information can be shared for any in-house counsel, for that matter, either parties, because these employees are bound by the confidentiality terms with the employer. How far can the court really control how much the information leaks? Just for that purposes of having sanity in terms of how this very important confidential documents are maintained, I think it's very important, at least in the Indian context, where we don't have proper trade secret laws, or we don't have proper measures or avenues for speedy adjudication in case there's a trade secret breach. I think just for the Indian jurisdiction, at least, it becomes very, very important to have it attorney's eyes only, because we need to respect confidentiality agreements between whichever party it is, either ways, and that's something that the parties have committed to the other party, and it has to be it's sacrosanct in my view, and that perhaps is something that we need to really make the courts realize that for either parties it can be a challenge to show it to an in-house counsel who may be there today, who may not be there tomorrow, and that we don't control how far this information goes. So thank you for that views, Mr. Anand. So I'll go on to now. So Saya, Mr. Anand commented briefly earlier on the Commercial Courts Act and the recent patent rules. If you have any comments, could you please share those?
Yes. So, Chitra, as Mr. Anand pointed out, that your patent rights are limited by term. They're just for 20 years, certain amount of time, and that's from the date of filing. So, certain amount of time is consumed in their prosecution. If it's a standard essential patent, then a certain amount of time is consumed in negotiation, because in view of the voluntary Frand commitment of a proprietor, you approach an implementer and try to negotiate and enter into a Frand license agreement. And then by the time the parties reach an impasse and a litigation is instituted in a court, there's a very limited time period which is left out of that entire term. Now, the legislature and the judiciary in general, the system that we have in place in our country, is aware about that fact, along with the fact that there's huge quantum of litigation in general before courts that every single judge has to deal with. Now, so in order to tackle this, I believe a lot of changes were brought about, starting from Commercial Courts Act, which drastically reduced the timelines. And earlier to the Commercial Courts Act, as Mr. Anand pointed out, expedited litigation was an exception where both the parties agreed to it, but now it has become the norm, thanks and courtesy to the Commercial Courts Act. You have case management hearings where you can request courts to give preference to one particular issue, because see, you can ask the court to decide infringement first, because if the infringement finding is against you, it really doesn't matter if your 7 patents or 8 patents or how many patents you've asserted are all declared to be valid. So you can ask for that sort of seriatim, which earlier wasn't provided for in the legislature per se. Then costs. Provisions have been added to ensure that actual costs are awarded and frivolous contentions are limited to the extent possible. All of that started with the commercial courts. Then came the original side rules, which were drafted by the Delhi High Court, where certain good practices, such as constitution of a hot tub, where you'll have technical witnesses who'll come and depose directly in front of the judge, as opposed to a local commissioner who'll record the evidence, so that the controversy is limited and sorted out. The provisions were introduced for the first time in the original side rules. You also had confidentiality club, as you discussed and Mr. Anand pointed out, being recognized for the first time in those rules, that you do require, and it's desirous to have that concept as a rule. Thereafter, we've seen IPD, Intellectual Property Division, coming into picture. Now, that was an answer to us, Mr. Anand pointed out, that constant change in roster. So ever since the IPD has been set up in Delhi High Court this year, we've seen 3 roster changes, but the judges who've been dealing with those particular sort of matters, they've remained constant. On the contrary, they've added a bench looking at the quantum of work. As Justice Singh in the previous session pointed out, that there are 4,000 matters, IP matters related, which are pending before the Delhi High Court, which are split over in between 3 benches. So that need was felt that we need someone more, and IPD ensured that that specific dedicated court was added to it. Thereafter, we've seen patent rules, which have come into picture. And if you see the objective of the patent rules, it specifically points out that on the basis of the experience which the Delhi High Court has garnered in the past 10 to 15 years, looking at how patent suits are generally dealt with and prosecuted before the court, these rules have now been sort of enumerated and pointed out. So, for example, in SEP cases, which we instituted early on in 2013, 14, 15, the concept of indirect infringement, where you map your patent to the standard and you show the compliance of the device with the standard, and that was sufficient to establish infringement, was always objected by the defendant, saying that, I'm sorry, this is something which is impermissible. You need to enter into an appropriate claim construction. You need to show as to how my device is reading onto every single element of your claim, and only then you can say that you've discharged your onus of infringement. Quite frankly, it was very, beneficial for them, because if I sort of establish patent infringement for one model or 2 model, and we know how quickly these models change, effectively there is no remedy for the patent owner. So this fact was recognized by the courts, and in patent rules now we've seen a specific rule being enunciated where they have said that for SEP cases you can prove infringement by showing mapping to the standard. So that was specifically relied upon. Secondly, SEPs, the fact that in SEPs it's not just about one or two patents being licensed, it's about portfolio licensing. That is again something which is recognized in the patent rules, where details with respect to the asserted patents or portfolio, depending on the case, whether it's a simple patent case or is it an SEP case, have been asked for. Again, the fact that the defendant tends to sort of raise multiple defenses, where the one stand would be, I don't know which technology I'm using, but I'm definitely not using your technology. So again, to counter that, the rules now require that, yes, the onus is on the plaintiff to establish that you're infringing, but you cannot get away with this defense. You have to disclose exactly what technology you're using. If you're claiming to use an alternate technology, you have to provide the details of your alternate technology. Then again, as far as confidentiality club is concerned, it was always about licenses that have been executed by the proprietor. Their own licenses were sacrosanct. But the patent rules now, for the first time, require even them to bring their licenses on the table. And we've seen in various, for example, in the Phillips matter, the Dutch Supreme Court sort of affirmed the finding of the appellate court, where they said that in order to initially assess whether what has been offered to you is Frand or not, your own license agreements provide sort of a guiding light, and you do not necessarily, during the course of negotiation, require license agreements of the proprietor. So all of these now, based on past experience that the Delhi High Court has seen in various patent cases, including SEP cases, have been incorporated as part of rules, as part of legislature. And the intent is obviously to sort of streamline the entire process to ensure that the time is reduced, because early disposal is something which is desirable for any judicial system, and that in turn will ensure that you have a robust IP protection system in your country, and which is something I think all of us endeavor to.
Very true, Saya. I think almost all of us in this panel live, breathe, and IP here. So I think we have around 6 or 7 minutes more in this panel. Of course, we will have some question answers from the audience, but I would like to have a few final words. If anybody in the panel has any suggestions on how things can be improved. Not that I think I can control any of it, but just for the audience and people concerned here to get some words of wisdom about how do you think we could do better in terms of. Shimoyu, I'll come to you separately after this on the competition commission. But for the other three panelists, any suggestions that we could improve upon, if you have anything?
This is Jim. The Make in India initiative that was announced a few years ago, I think is really fascinating. I think the work that India is doing, it's stressing the importance of innovation among its researchers and its institutes is a great step forward. I really think that model where you have the students or the professors working on standards projects, and then being able to protect those innovations, to protect that R&D spend with the standard essential patents and related intellectual property is a good byproduct. So I really like seeing what India is doing with the Make in India initiative, and congratulate the government for that work. So, but no other specific comments.
Yeah, India is the startup hub, I think, right after US and China. I think little ahead of Israel. And there's a lot happening on the front. And it's really good to see that the government is supporting that initiative. It helps a lot of people at the grassroots level. And it's quite a nice program. Saya and Mr. Anand, do you have any comments? Or I've already heard lots of words of wisdom from both of you. But anything else, if you want to comment before we move on?
There's one of the major defenses that comes up is that before any kind of a security deposit is made, there should be a determination of validity and essentiality. And if you look at it with a large portfolio of patents, and particularly a large portfolio at the global level, even in India, and the large number of claims per patent, then the total number of claims might add up to maybe 20,000, maybe more. In some cases, I have calculated 100,000. Now, the probability of all claims being bad or invalid is almost negligible. And therefore, even if one claim of one patent is being violated by the implementer, then an injunction can be granted by the court, particularly if the implementer has shown an unwilling conduct. And I think Unwired Planets actually uses some expression to the equivalent, which is equivalent to saying one bullet kills. And so the question, therefore, is that if you go by the law of probability, that the court can presume, particularly if it's the case of an ex-licensee who had taken a license, who had agreed to all the terms, and just because the license expired, suddenly for him, the patents all become bad and every claim becomes bad, highly unlikely. That's one issue. The other issue is that we always sue for a few handful of patents because it's not possible to sue for, let's say, 5,000 patents or 2,000 patents. Even if there are, let's say, 100 patents in India, it is not possible because that would be an impossible suit. So it's representative suits, representative patents are used in the negotiation process and also in the lawsuit is a perfectly legitimate international practice. So those are two important principles which I find, which are being, they come up repeatedly. Like I think Mr. Lal said in the previous session, a standard essential defense. So I believe those are my remarks on what I feel about those two defenses.
So, Saya, anything you would like to add?
Chitra, I completely agree with what Mr. Anand said just now. And now, based on the discussion that Mr. Lal and Justice Singh had prior to us, what I could garner was that the judicial system is also aware about this, and they're working towards streamlining the process and ensuring that the proprietor is not left remediless. We've seen IPD and patent rules come this year, sometime in March, April. And as Justice Singh pointed out, give us about a year or so, and you'll start seeing the jurisprudence settling in the country. So I can just hope, as a lawyer, that it actually ends up coming true, and end on that hopeful note.
Very heartening to hear that. In fact, thanks for repeating that. So, Shribuyi, I'll come to you. And do you see any changes or opportunities to improve on the CCI? Are they working or anything?
Yes. So, thus far, the CCI has not passed any or has not made any final determination in cases involving standard essential patents. But what they really, I mean, what I would think is the need of the hour is for the competition authority to understand that just because somebody has gone and approached a court for seeking injunction, that doesn't mean that there is a potential violation of competition law in terms of abuse of dominant position, because the Constitution of India, or what I would say the Supreme Court of India, have actually recognized and granted that the principle of ubi jus ibi remedium is a fundamental principle of law, which provides, or which basically which confers a duty on the courts to protect the person who has been given legal rights. So the court should act as a protector rather than denying that relief to the person who's aggrieved. So, given that even the CCI would be bound by what the Supreme Court says here, so these are, I mean, while deciding, or while sort of making a choice or a decision to investigate a matter, the CCI should look at all the surrounding circumstances, all what is the nature of negotiating history, and to what extent are the parties engaged in litigation before a different fora. To what extent there has been a double speak on the part of any party, whether they are challenging or they are making some arguments which is before any other court in India, which is totally contradictory or contrary to what is being stated before the CCI. Lastly, I would say that currently the competition regime in India does not provide for a withdrawal mechanism, because what usually happens in Frand, this SEP realm is that there is a negotiation which is going on between the parties, and often the competition complaint or an information with the CCI is often used as a mechanism to try to get try to put some negotiating pressure or gain some leverage in the course of negotiations. So once the parties settle between themselves, there is no mechanism currently where the parties can actually withdraw the proceedings which are going on before the CCI, because the CCI takes a view that the proceedings before the CCI are in rem proceedings and not in personam proceedings. So even if the disputing parties have settled the dispute between themselves, they will still continue with the investigation, and they will go through the entire process of investigation, which is often a time consuming and putting a lot of burden on the resources of the company which is being investigated. So this is one thing that I feel that should be taken into account when it comes to the adjudication on matters involving standard essential patents from the perspective of the CCI.
Thank you, Srimurti. I think that was a very interesting comment you made. And
Chitra, I want to add to that. Do we have the time for that?
Absolutely, Saya. I think Hiteshi, please grant us a few more minutes.
I'll just take 1 minute. So I just wanted to add one thing that, we have seen, as Srimoy pointed out, as an offshoot of patent assertion, patent infringement suit being filed, there will be a competition commission complaint, where the main issue or the main grouse would be that the rates which were offered to us were not fair, reasonable, and non-discriminatory. Now, we've seen that the CCI has taken a stand where they've said that, we are not a rate setting organization. We will not go into all that aspect. So, in a sense, what they will go into, if there is any grounds with respect to conduct, etc., that, a proprietor completely refused to grant a patent, did not negotiate ABC. Now, with case laws as far as patent infringement assertion, having sort of settled that the starting rate need not be Frand. And just because that is not Frand does not mean that you haven't complied with your Frand commitment. That Frand is a range. Non-discrimination does not mean that you treat everyone uniformly. With all these guidelines being there and the question just being limited to rate, the mechanism of withdrawal, as Srimu pointed out, that becomes very important, because if you're not going to set the rates, if you're not going to investigate the rates, and the courts have already said that there is the broad guideline, and ultimately the court finds out that even if what was offered was not Fran, but that does not mean the conduct could be said to be sort of something which adversely affects the competition. This withdrawal mechanism becomes very important then.
Thanks a lot, Saya, and thank you, Srimurti. I think that was a very insightful observation from your side, Hiteshi. And I would like to thank the panelists, I think, and also the audience. It's been a long day today, and if you have the energy to be at this session,
can I just take 10 seconds?
Yes, Mr. Anand.
10 seconds.
Yes,
just to
sure.
clarify,
Sure.
in relation to the roster issue which I brought up, that is a pre-IPD issue. And I believe that the IPD has solved that, and therefore, hopefully, that roster will continue. And
Sure.
So I just wanted to clarify that my comments may not be misunderstood.
No,
That was a
no, no.
pre-IPD.
Yeah, I think that was a historical perspective. So
Exactly.
now it's
exactly.
much better. So I would like to thank.
Many positive changes, and we hope for the best now.
Indeed, Mr. Anand, thanks for calling that out. Deshi, if you have questions from the audience, maybe you would like to ask.
Yeah. So one of the questions we have is, are there any loopholes or deficiencies in the current policies and laws relating to IPR in India? Does the long waiting period in patent offices affect the granting of SEPs?
To whom is it addressed?
Is it directed to someone?
No, it is not. It is just a question to any of the panelists who may want to answer.
I think that was also already discussed. Deshi, maybe it was before it was answered. I think it was already answered, yeah.
I mean,
Should the another question, should the regulators or government get involved, because this is a matter between two parties?
I think Mr. Anand was saying something on the previous one. Also.
On the previous one, I just wanted to make a very quick comment.
When developing a standard essential patent that goes along with the technology, you've got to think about process at the patent office is different from the process in the standards body, and the two don't interact, right? So you can have patent examiners that think that there's something, not new and not unique and unobvious, and don't allow a patent, but it could be new and interesting and unique and non-obvious to the technical standards body. So sometimes what an inventor or a contributor might think is a novel solution to a problem, a patent examiner might say, no, I don't think so. Or converse can be true, so there's separate paths, and that's one of the tough part, is that making sure the claims match what is eventually part of the standard. So that's a whole other discussion in like a 2-day, seminar on how that works.
Right. Yeah, Chitra.
Okay. Yeah, any other questions?
No, that's it from.
Okay.
We don't
In
have
that
any more.
case, I would like you to take over the panel control, Teshi, and vote of thanks.
Thank you, Chitra. Thank you, Mr. Jim, Shrimoy, Mr. Praveen Anand, Saya, for being with us and giving us your valuable insights. That was a wonderful session. And this session actually brings us to the end of the conference, and we had a day full of inputs from every speaker, and just re-energized on the topic. So I, at the behest of the organizing committee and IP Ethicon, Law Center 2 Entrepreneurial Clinic, Delhi University, and ICC, would take this opportunity to thank all our esteemed speakers who have given their valuable time today. And they put their knowledge into words for us. Thank you so much. Thank you, Dr. Civil, for being the part of the organizing committee. And without you also, it wouldn't have been possible. Thank you so much. You may just want to conclude, Dr. Civil. You're on mute, Dr. Civil, I guess. Yeah.
Wait.
Yeah, you're given the rights. You can unmute.
Okay, thank you. I'm so sorry. I got disconnected for some time, and when I rejoined, I lost the control. I was no more the host for the conference. Thank you so very much, Hiteshi. Thank you, IP Ethicon and ICC, and special thanks to stalwarts like Mr. Parveen Anand, Saya Chaudhary, and other speakers who illuminated these sessions throughout the day and who kept the audience engrossed and engaged. As an academic, I would like to say that this has been an enriching experience for me as well as for my students, and we are hopeful of having a lot of learnings from this conference. We will be definitely publishing a report of this, and we are looking forward to much more collaborations in future in the ensuing time on such topical issues with IP Ethicon and with other platforms. Thank you very much. I extend a heartfelt gratitude to Honorable Justice Pratibha M. Singh for for having consented to grace this occasion, and for her enriching fireside chat too. I also take this opportunity to thank Honorable Dean, Faculty of Law, University of Delhi, Professor Usha Tandon, for finding time and for delivering the presidential address in the inaugural session, and Professor Mahavir Singh, the professor in charge of Law Center 2, for reposing faith in us and allowing us to, conduct such an insightful event. Thank you so very much to everybody, including the participants, the attendees who have been glued to the screens since 2 o'clock today. I have been continuously monitoring and observing that the audience, the number of attendees has not gone below 100 since 2 o'clock. It was 170, the highest, I believe. So it is an encouraging and overwhelming response which we have received from the audience. And thank you, all the organizing members, the team which worked so hard for last a fortnight or for almost full month in making it successful. Thank you very much.
Thank you so much. Thank you, everyone, for your wonderful time. Thank you, all the speakers and the panelists. I'm sure looking forward to have this kind of many more such event in the coming time.
Correct.
Thank you, Dr. Civil. Thank you.
Thank you.
Thank you, ICC, Indian Chamber of Commerce. And thanks to all the panelists and the speakers. Thank you so much.
Thank you.